3. Is it?
We froze here.
Looks like Jeff's connection is a little bit slow. Give him a minute to get his connection cleared up.
Yes, good. Karen, as Karen was reading there, what you notice first thing is there is an Article 3 of the Constitution. We shouldn't overlook that. What that means is, as you know, here that on the screen we've got Section 1 and Section 2, the judicial power shall be vested in the Supreme Court. It was a new thing to have a federal judiciary. That's not an insignificant fact. If we're trying to understand the power of the Supreme Court as we see it articulated in Marbury versus Madison, what was John Marshall trying to do? You got to go back to his understanding of Article 3 itself and the purpose of it. In Section 1, we simply see that, in fact, there is a federal branch of the judiciary. That had not existed under the Articles of Confederation. Those of you know who teach American history, you know that never before had there been itself a separate federal court system. The Articles government relied on a state court system to apply and interpret federal law, such as there was. So we have a new thing in Article 2, as we have a new thing in Article 3, as we have a new thing in Article 2, the presidency. There was no separate executive branch under the Articles, and now we have one in Article 2. Article 3, under the Articles of Confederation, there was no separate judicial branch. Now in Article 3, we have one. So first of all, we have this separate independent branch. It has the judicial power, as you were reading. But it, interestingly enough, does not say what the judicial power is. And this is part of the task that John Marshall has in Marbury versus Madison, to define something, to define a power that the Constitution itself does not define. If you wouldn't mind, then keep reading for us. So one thing I would say is Article 3 is designed to create an independent judicial branch. The first thing we see is it's independent in constitutional status. It's created here in Section 1. Congress doesn't create the Supreme Court. Congress can't abolish the Supreme Court. It has separate independent constitutional status. Whoever was reading, if you would keep reading for us there where you left off.
Okay. The judges, both of the Supreme and inferior courts, shall hold their offices during good behavior and shall, at stated times, receive for their services a compensation which shall not be diminished during their continuance in office.
All right. Thanks, Karen. The next thing we see is the two other ways in which the Supreme Court has independent status. The one is it has an independent constitutional position, as I was saying. Second is, as you can see here, they have independent tenure. They hold their offices during good behavior. They're not elected. They're not subject to recall, unlike in some state courts, in court systems, even here in Ohio, for example. And early on in the Republic, it was a settled kind of constitutional rule, a custom, that good behavior meant you couldn't be thrown out for decisions that people didn't like. In other words, bad decisions were not bad behavior. There had to be criminality involved. There were early impeachment proceedings where that became clear that was going to be a constitutional custom. So the judges have independent tenure, and that tenure is not dependent on what people think of their decisions. Unless there's obvious negligence or gross misconduct, it's just because you disagree with a decision doesn't mean that they're behaving badly, so to speak. So that's the second thing, independent tenure. And the third thing here, independent compensation. The obvious reason for that is that they can't be starved out of office. As in England, judges had their office during good behavior, but their salaries oftentimes were subject to the discretion of the monarch. And obviously, if the judges made decisions the monarch didn't like, they could have their pay reduced, or they could have their pay increased, of course, for the sake of a bribe. But certainly the other way around, making unpopular decisions that offended the monarch or offended Parliament, their salaries could be diminished. our Constitution says no, they're going to be independent from that kind of financial pressure, and they're going to have not only independent status, independent tenure, but real effective independence by not having their compensation reduced. And a lot of these ideas do go back to England. The good independent tenure, holding your office during good behavior, goes all the way back to the Settlement Act of 1701. So these are old English customs that continue on into our Constitution and are now enshrined in the written law. So that's the first thing. Section 1, I think, lays out the notion that the court has an independent institutional status. That's something that John Marshall talks a lot about in Marbury versus Madison. He really thinks it's fundamentally important that we get that about the court, that it has an independent institutional status. And part of the decision in Marbury, I would argue, cannot be understood without realizing that Marshall's very deeply interested in trying to protect the court's independent institutional status, that it's given here in Section 1 of Article 3. All right, Karen, could you please keep reading for us in Section 2? I think what you're seeing in Article 3 is an overall attempt. The fundamental purpose is to establish independent courts of law for the federal government. If you want to say, what's the overall point we take from this? It's that Article 3 is trying to establish independent courts of law for the federal government. Section 1 establishes their independence institutionally. All right, Section 2, please, Karen.
The judicial power shall extend to all cases in law and equity arising from under this Constitution, the laws of the United States and the treaties made, or which shall be made under their authority.
Very good. Stop.
Okay.
That's good. You can stop there for a moment. Thanks. And then the rest of the discussion is the specifics of other kinds of cases. And when you look at Section 2, I think what you're seeing here is the founders saying, Section 1 says an independent constitutional status. Section 2 says that the Supreme Court will be independent and the federal courts will be independent by having an independent jurisdiction, that their jurisdiction will not be subject to complete control by Congress or by the executive, that the Constitution spells out what cases they can hear, and it makes it clear that they can hear those cases. And of course, that's an extremely important idea. Marshall talks about it again in Marbury. Where courts can hear cases, they have power to decide. Where courts can't hear cases, they don't have any power. And if you can control what cases the court can hear, you can control that court. And Article 3 here in Section 2 makes it clear that Congress and the President will not be able to control the court's jurisdiction. It has independent jurisdiction, subject to some regulations, but fundamentally, it has its own jurisdiction that can't be tampered with except by tampering with the Constitution. Over and over and over again, it's kicking me out. I think we have a Mac problem. I need to get set up somewhere else.
Seems like we're having a difficult connection this morning, but thank you all for being patient. Jeff, you're back on now.
Good, great. I'm sorry, I'm being kicked out here. But let's go, as I was saying, let's go to Article 3, Section 3, and see another aspect of the court's independence. Karen, if you could read that for us.
Sure. Treason against the United States shall consist only in levying war against them, or in adhering to their enemies, giving them aid and comfort. No person shall be convicted of treason unless on the testimony of 2 witnesses to the same overt act, or on the confession in open court. The Congress shall have power to declare the punishment of treason, but no attainder of treason shall work corruption of blood or forfeiture except during the life of the person attainted.
Okay. Let's take a hand here. Someone want to answer, why is this in here? Why is Section 3 in here? That we have a constitutional definition of treason. How does that help us? How does that advance the idea of independent courts? Someone, what's your guess here? What would you think? It's the only crime actually defined in the Constitution.
Would it be based on the presidency?
Go ahead, please. What do you mean?
Well, it talks about the president can be removed from office. High crimes, misdemeanors. Would it have to do with that? That it's trying to define that in case impeachment would come up against the president?
Well,
okay.
If the president is impeached for treason, right? Although of course
okay.
the president can be impeached for lots of things other than treason. Obviously, Bill Clinton in 1998 was not impeached for treason.
Right.
So how does this help us? I certainly think that's part of it. But how else does this help us? An independent constitutional definition of treason that Congress, for example, cannot change by law. How does that help the independence of the courts?
Mike, do you want to go ahead?
Please, go ahead.
Mike Hoffman?
Yeah, I'm trying to speak. I'm not
go
sure
ahead.
I'm being heard.
We can hear you. Go ahead.
Go ahead, Mike.
Sorry. I thought about what Karen thought about also, but does it not also protect the court when it makes decisions from being accused of being treasonous?
That's right. I think exactly that's what you're seeing here. You're seeing an attempt by the founders to not let courts become instruments of political repression. The favorite the favorite way to get at your enemies in England, as you know from English constitutional history, was to accuse them of treason and lock them up in the Tower of London. That was a famous way to get at people that you couldn't otherwise get at, because treason was so open-ended that many things were possible, and many avenues of attack that you could take against your political enemies. Well, if it's defined constitutionally, what that means is courts themselves cannot become engines of prosecution of treason, because if you're prosecuted, you have a clear definition of what treason is. And I think even more importantly, courts can't become instruments of the executive or the Congress, which might want to define treason in a certain way so it could use them as instruments of political oppression. This is a very common thing. We've seen this in a lot of 20th century revolutions, the Bolshevik Revolution in Russia, the Nazi Revolution in Germany, the Communist Chinese Cultural Revolution in China, the Iranian Revolution with Khomeini. All of those revolutions, they didn't just throw people in jail and execute them. Oftentimes, they had show trials. Section 3 does not permit the courts to become places of show trials, of political oppression, getting at your enemies by sake of treason. So if you look at Section 1, the court has independent institutional status with a constitutional position, with independent tenure, with independent compensation. If you look at Section 2, it's got independent jurisdiction. And if you look at Section 3, it's got political independence from being used as an instrument of oppression, which traditionally courts have been used for. Again, I think the notion behind all this is the founders are saying that we want an independent judiciary. And that was not lost on the anti-federalists, the people opposed to the Constitution. There was a very famous anti-federalist called Brutus, who wrote a number of essays in the state of New York and published them attacking the Constitution and especially the Supreme Court. And in Brutus number 15, he actually argued that, yes, the Supreme Court, Article 3 really establishes an independent court, so independent that it will be independent of everybody in the country. It'll be independent of the Congress. It'll be independent of the president. And eventually, he says it'll be independent of the people themselves. And he goes on to conclude, a court so independent will pretty soon think that it's independent of God himself. And it will think of itself as God for the entire country. Sometimes this has been called by scholars, contemporary scholars, as the notion of an imperial judiciary. That the court begins to think of itself as the emperor of the country, deciding everything for the country. Brutus, number 15, published way back on March 20th of 1788, makes exactly that argument. It says, yes, it'll be so independent, it'll be too independent. It should be more like the courts in England, Brutus argues, subject to appeal to some political body. In England, for example, you could appeal from the courts to the House of Lords as a court. And when they sat as a court, they're called the law lords. Brutus says we should do something like that ourselves. You should be able to appeal from the Supreme Court to something like the U.S. Senate. There should be some final check on the court, or it will become this monstrous body that concentrates all power in itself and decides the whole course of the country for everyone, unchecked by anything. That's the argument Brutus makes. And I say that because that's the context in which we get Federalist number 78, which was another reading in your readings packet. Alexander Hamilton replies to Brutus, published on June 14, 1788, a few months after Brutus's. Hamilton says, wants to respond to the charge of Brutus, that the Constitution has created an independent judiciary, so independent that it will become supreme over everything in the country. And he does this, he defends the Constitution, Hamilton does here, by focusing on one thing that's very uncontroversial. Judges should have tenure during good behavior. And as he says here at the beginning, this is completely a normal, uncontroversial idea. If you look at the first, second, third, fourth, fifth, sixth paragraph here on Federalist 78, it starts, according to the plan of the convention. You can see that. I'll just read it. It says, Hamilton saying, according to the plan of the convention, all the judges who may be appointed by the United States are to hold their offices during good behavior, which is conformable to the most approved of the state constitutions, and among the rest, to that of this state. In other words, a lot of state constitutions have good behavior. It's an old English tradition, and here in the state of New York, we have it as well. Its propriety having been drawn into question by the adversaries of that plan is no light symptom of the rage for objection which disorders their imaginations and judgments. The fact that the anti-federalists like Brutus would oppose this, he says, just shows you how crazy they are. But, you know, that's pretty good political polemic. But the truth is, there was some traction to that charge of the anti-federalists. Look, we've created a new thing, an independent federal judiciary. We're not relying on state courts anymore. We've given it a lot of independence. Why won't it become the most dangerous branch of the Constitution, of the federal government, and dominate the entire country? And the rest of this essay is devoted by Hamilton to showing why it won't become what Brutus prophesied that it will become. And at Federalist 78, we could have a long discussion of it. There's so many interesting arguments, but let me just point out a couple of high points that I think it's important to take as we go into Marbury versus Madison, which is that Hamilton argues that such independent judges are not dangerous because they do not have the capacity to harm the Constitution. And he has the very famous part where he talks about, as you know from your reading, look, the court does not have the sword like the executive. The court does not have the purse like the Congress. And therefore, it doesn't have force, and it doesn't have will. All it has, as he very famously says, is judgment. And he says, as the paragraph that we're looking on right now up on the screen, the first full paragraph starts the complete independence of the courts. Again, I'll read that for you. Here's why Hamilton thinks it's particularly important that you have independent courts with independent tenure. He says, All right. Yes, the complete independence of the courts is an essential, he says here in this paragraph, to a written constitution. Because the notion of a written constitution is government has some powers, some things it's forbidden to do. How can you enforce that unless you have courts that are independent and that can protect citizens from prosecutions and from powers that government is not supposed to be using and not supposed to be using in that particular way? It says it's particularly essential in a limited constitution because it's the only way to preserve limitations on government, is the power of courts to declare legislation unconstitutional and void, what we call judicial review. Look, all the way back here, you can see this in 1788, Hamilton is saying courts will have the power of judicial review. That's not something new. As I said before, that's a myth of Marbury, that somehow Marshall established that practice in 1803. Hamilton's already talking about it here like it's a widely accepted fact way back in 1788. But of course, there'd be this objection from the Anti-Federalists. But won't the Supreme Court become more powerful than the other branches if it has the power to declare what powers they have and don't have? Can it set itself up as a kind of super legislature deciding what powers the other branches have? And Hamilton replies later on in the Federalist 78. I think this is very important, where he says, no, you're misunderstanding the power of judicial review. And this is the point that Marshall will also take up in Marbury. Judicial review is not dangerous if it's understood properly. And what Hamilton says here in Federalist 78 is that judicial review is really a shield, not a sword. It's really a shield to defend the independence of the judiciary. It's not a sword to hang over Congress and the president to make them do what the Supreme Court says they should do. And he says, well, why is that? He says, well, because you have to understand the argument underneath judicial review. And the argument, as he lays it out, is fairly simple. First point he makes is Congress can't pass unconstitutional laws. We all accept that. He says, well, all right, if they can't pass unconstitutional laws, then somebody's got to be able to check the law and that they pass. Otherwise, they would, in effect, be able to pass unconstitutional laws. And he says, Congress wouldn't naturally be the interpreter of its own powers, because you can't be a judge in your own case. Who would naturally be the interpreter of Congress's laws in order to check them constitutionally? He says, the courts, the federal courts, and especially the Supreme Court. Why should the courts interpret the Constitution? He says, well, as a matter of checks and balances, but he also says that famous line here from Federalist 78 where he says, the interpretation of the laws is the peculiar province of the courts. Why? He says, well, because that's what courts do. Their job is to interpret law, but not simply really to interpret law. Their job is to decide legal cases in front of them. That's what they need to do. They need to decide the legal case in front of them. That's the judicial power. Any of you ever been to court, you know that's what judges do. And so what he says here is, in order to decide the case in front of them, they need to be able to interpret the law. You know, for example, if I'm charged with reckless driving by the state of Ohio, this is a pure hypothetical, of course. If I'm charged with reckless driving, I go to court and sit and am tried and charged in front of a judge, and in sitting trial in front of a judge, the state will produce evidence saying this is what I did. Here's what Sikkenga did. He swerved over the line 4 times on the highway. We're charging him with reckless driving. We think he's guilty. But notice what the court has to do. The court has to decide, is swerving over the line 4 times, does that constitute reckless driving? Well, in order for a judge to make that decision and find me guilty, he has to interpret the meaning of reckless driving. Evidence establishes what I did, but only interpretation of the law can determine if what I did actually violates the law. So Hamilton said that's why it's the peculiar province of courts to interpret the law. Not because that's their fundamental job. Their fundamental job is to decide legal cases that come in front of them. Marbury versus Madison, Roe versus Wade, Brown versus Board of Education, right? Decide the legal case, who wins it. But in order to decide the legal case, they've got to be able to interpret the law. So judicial review, actually, Hamilton argues here, is a very modest power. It's simply the means that courts have to achieve their end. And their end is to decide the legal case in front of them, to do justice according to the law in a particular case, as the famous common law definition from Blackstone. So that here is why Hamilton concludes Federalist 78 by saying, look, don't get all upset about this power. It's not a power that's going to put courts above Congress or the president. It's a power that's going to put courts on an equal plane with Congress or the president. Because if Congress passes a law that's unconstitutional, that law, and prosecutes someone under that law, for example, if a person goes into a federal court, they will be shielded from prosecution in that federal court. That's all it means, he says. It's just a power to prevent unconstitutional actions and laws from having any effect in a court of law. That's what void means. Void does not mean, Hamilton says here, does not say that it means that it has no effect throughout the entire country or that the other branches have to obey what the court says. It simply means that the court itself does not have to obey what the other branches say. Like I was saying, Hamilton's argument in Federal 78 is judicial review is a shield to protect the independence of the judiciary. It is not a sword to establish judicial supremacy over Congress or the president. And why should judges do this? At the end of the piece, he says, well, it's better that they have this power because they're judges, they know the law, and they know what is necessary to ensure due process of law in their courts. And that's the fundamental purpose of judicial review. And again, this is in 1788, way before Marbury versus Madison. And not surprisingly, given the powers in Article 3, and given Hamilton's defense of them in Federal 78, it's not surprising then that the federal courts begin almost immediately from the time of the Constitution gets going. They start practicing judicial review. You know, just a few statistics. Well, why don't I see a couple of questions. Why don't we take a couple of questions, and then we'll move on. I want to just talk about some of the statistics here that you don't hear about much about how the courts were practicing judicial review, and then go into Marbury. But maybe a good time now to take a couple of questions.
Jeffrey, it looks like your hand is up. Do you want to go ahead? Go ahead, Jeffrey.
I can't.
Go ahead,
Can
Jeffrey.
you hear me?
Yes, go ahead.
Can you hear me?
Yes,
go ahead.
Okay. Well, the question I had was when you were talking about, let me see here, Article 3 of the Constitution, Section 3. When it says here that no attainder of treason shall work corruption of the blood or forfeiture except during the life of the person attainted. What does he mean by? What do they mean by that?
Good question. That goes back again to England, and it's an old English notion. Corruption of the blood is the notion that if your father was treasonous, you also will be treasonous. In other words, it's sort of guilt by association, and that notion is not permitted in the U.S. Constitution. Like, you know, the notion of a family of traitors. And the reason that came out in England, of course, was, on the one hand, it was just a way for kings to be able to get rid of a whole line of prospective enemies. But also in England, of course, you have a very strong aristocratic tradition. And so certain houses, certain noble houses would actually be set up to think of themselves in opposition to the particular king who was monarch who was king at the time. So it might actually be true that there was a whole family of traitors. But in America, where you don't have aristocratic families who are bound together by titles of nobility and all the rest, it doesn't make any sense. And of course, also it's just an unjust way to prosecute people. So it's put in the Constitution to prevent that.
Looks like we have one other question from Alexandra.
Please go ahead, Alexandra.
Alexandra, do you want to go ahead?
Yeah, I apologize for this because I'm a recovering English teacher. But on paragraph, I don't know, I haven't numbered the paragraphs, but it looks like page 1, 2, 3 of the Federalist, of Hamilton's Federalist paper. It's like the third paragraph down, and what he said was, They teach us that the prior act of a superior ought to be preferred to the subsequent act of an inferior and subordinate authority, and that accordingly, whenever a particular statute contravenes the Constitution, it will be the duty of the judicial tribunal to adhere to the latter and disregard the former. And so my question is adherence interpretation. I mean, because when you get to Jackson's comments about, the decision on the Bank of the United States, and you have this issue of it's every individual's responsibility who takes the oath of office to interpret the Constitution and then to sort of execute it as they see fit. And you have issues of, clearly politically, the Supreme Court's made some, frankly lousy decisions. So, is there a difference between adherence and interpretation? I can see that maybe, these men didn't understand the sort of Leviathan that this would become with political appointments to the federal bench, and then that's how people end up on the Supreme Court. So, this idea of adherence versus interpretation, like, where do you think, is there any way to read into what Hamilton actually meant when he said that?
Sure, that's a really good point. I think that goes back to, that's a great question, because it goes back to what Hamilton said at the beginning of Federal 78, which is, he says the Supreme Court doesn't, unlike the president, the Supreme Court doesn't have the sword. Right? He says it doesn't have force. Unlike Congress, the Supreme Court doesn't have the purse. It doesn't have the power to tax. He calls that will. He says, well, what power does it have? He says it just has the power of judgment. And I think that's what he means by adherence to the Constitution. He thinks the courts should only make judgments according to the law and interpret the Constitution as close to the meaning of the Constitution as adopted as they can. And Hamilton's view is that's the only way to keep courts adhering to the Constitution rather than starting to exercise will. They're not legislatures. They don't get to decide what's best for the country, in other words. That would be will, right? Congress passes a law and says, what's best for the country in interstate commerce? And they make a law. That's not the question the Supreme Court is ever supposed to ask, according to Hamilton. They're not supposed to ask what's best for the country. They're supposed to ask, who wins this legal case? And that's all we're supposed to do is decide that, and we're supposed to adhere to the Constitution as closely as possible in making that decision. So I think, yeah, there's a difference. He would say, of course they have to interpret, but he would hope that their interpretation is guided by the notion of being as close to the Constitution as possible and only interpreting the Constitution as much as is necessary in order to decide the legal case in front of them. And there's actually a long canon of judicial ethics that say it's called it's one of the doctrines of judicial restraint, which is you only interpret you'll like this as an English teacher. You only interpret as much of the text as is necessary to make your decision. So don't give us volumes and volumes and volumes of interpretations of the whole thing. Just give us what you need in order to make the decision. So, and that if you go beyond that, there's a term for it. It's called dicta, which just means the court's just saying stuff, but it doesn't have any actual weight in deciding the case. And now, what is dicta and what is necessary to decide the case, of course, is always the subject of controversy. But the basic canon of judicial interpretation is you only interpret as much as is necessary to decide the case and no more than that. If we go beyond that, then we're actually starting to exercise will and not judgment. We're starting to just interpret rather than interpret in order to adhere to the Constitution. I think that's how Hamilton tries to parse that meaning of adherence.
Jeff, we have a couple other hands up. I see two more hands up. I'm going to call on David Fawcett. You have a question?
Please go ahead.
Yes, sir. I understand that that the court under 78 doesn't want to legislate. It wants to decide. But the text is pretty clear that any law contrary to the Constitution, it is the business of the court to decide its constitutionality if some kind of test should come up. So, granting that there's something of a fine line here, nonetheless, the power of judicial review seems pretty foursquare, at least as I read 78. I'm a little confused here. Again, the line between legislating and judging seems to be a fine one, but again, the text is clear that it is the business of the courts to decide what the law is. That's my question.
I would completely agree with you, and that's exactly the point that Hamilton is making. It's the business of courts. Necessarily, they have to interpret the meaning of the Constitution. But why do they do that? Hamilton's argument is not that the United States Supreme Court is a constitutional court. Its job is not to sit in judgment and tell the country the meaning of the Constitution. Its job is to be the final court of appeals in the federal system in order to decide the legal case that comes in front of it. Now, in order to decide the case, sure, it has to interpret the Constitution. But what I think Hamilton wants to argue here is it doesn't sit as a constitutional court, let's say, unlike the Supreme Court of Canada, which actually is a constitutional court, and Parliament can refer legislation to the Supreme Court of Canada and say, we're thinking about making this law. If we do, will it be constitutional, right? The Supreme Court does not have that reference power. That was actually decided very early in the 1790s by the Supreme Court itself. It said, look, we're not a constitutional court. Our job is not to tell you what the Constitution means. Our job is to decide legal cases that come in front of us. In order to do that, sure, we have to interpret the Constitution sometimes. But lots of times that means, therefore, practically speaking, they'll try to avoid interpreting the Constitution. There's a very good case, a case called Ashland v. TVA from 1935 about the Tennessee Valley Authority. Famous case where Felix Frankfurter, well-known justice, said, look, our job is not to tell the country the meaning of the Constitution. Our job is to decide legal cases. That means we should restrain how we use our authority in order just to decide legal cases. And he lays out a bunch of rules that he says have been developed by the court for judicial restraint. And it's in the concurrence to, like, I think it's Ashland v. TVA from 1935. And it has become kind of canonical for a lot of Supreme Court justices in saying, yeah, we're not supposed to just tell the country what the Constitution means. We're not supposed to cherry pick cases so that we can decide interpretive issues. We're supposed to interpret so that we can decide cases. Now, you're right in suggesting the Supreme Court doesn't always do that. Sometimes they make rulings that are really broad and go way beyond what is necessary to decide the case in front of them. But the basic understanding from Federalist 78, and I think I would also argue from Marbury versus Madison, is a much narrower view of what judicial review is to be used for. Not that there isn't judicial review, there clearly is, but what it's to be used for is just to decide the legal case in front of them.
Thank you.
Mm-hmm.
Jeff, it looks like we have two more questions on the queue.
Sure.
Jeffrey Butch, do you want to go ahead?
Yes. Can you hear me?
Yes.
Okay.
Go ahead.
I like what you've been saying about the court here, but one of the questions I have, and I think many Americans would probably ask, is that if the court is supposed to literally interpret the Constitution, then why do we have members of the court that are constantly sometimes doing that broad interpretation of what the founders meant? And in effect, it does affect the law of the country and the rule of law in the nation.
Sure. That's a question that I wanted to raise once we get through with Marbury versus Madison, because naturally that sort of, if that's what the original understanding was in Federalist 78 and in Marbury, how do we end up with such an expansive Supreme Court with such an expansive view of its powers? That's a really interesting story. I actually want to get to that once we get through Marbury. So I'll just bracket your question. But yeah, because that's the obvious question, and it's extremely important for understanding American history. Right. Good.
And,
any other? Go ahead.
There was one other hand up, which is now down. Alexander, did you have a follow-up question?
Well, it was just the question of, because Hamilton's making this case, right, that it's because the judiciary is the weakest of the branches, but this power of judicial review, by saying, I think you're going to get to it with Marbury, which is why I put my hand up, but by saying that that they have this ability to review the laws, I mean, in effect, you are putting them above the legislature, because the will of the people then could be subordinated to the decision of the judges. I mean, assuming that Congress actually listened to us, that could be the case. But I think you're going to get to it, so you know you can just shelf it. Mr. Shelf it.
Okay. Well, but that's yours and David's question are coming from the same sort of angle. So I think that's important, and it's also a real concern that Marshall has in Marbury. So you're right. Let's do that when we get to Marbury. But keep that question in mind because I think that's the question, especially for us today when we have a Supreme Court that really, no matter what, liberal, moderate, or conservative on the court, all of them believe the Supreme Court is the final authoritative interpreter whose job is to tell the country what the Constitution means. I mean, the judicial philosophy makes almost no difference in that fundamental point. But that's not the original, my argument is the original understanding. But let's go to Marbury and we'll deal with your question. That's a good one. Marbury itself, it's really important to understand the historical context of Marbury. We read it, we really read it completely torn from its context, and we read back into it everything that we think today about the Supreme Court, and it does a real injustice to the decision itself. So I want to just lay out for a couple of moments what's the historical context of Marbury and how does it help us understand the decision. And I would say that it really, to understand the decision, you have to understand that the Marshall Court in 1801 and 1803 here is caught in two conflicts. The first conflict is they're caught between the weakness of the court as an institution. I mean, it is laid out in Article 3. It does have the power of judicial review, but the court as an institution is really weak. Compared to Congress and compared to the presidency, nobody wants to be on the Supreme Court. They can't get a Chief Justice until John Marshall, who will stay. John Jay, for example, refuses to be reappointed so he can become governor of New York. I mean, New York was an important state, but today I think most people would say, really, you be governor of New York, not the Chief Justice of the Supreme Court? That's a little, unless you have presidential ambitions, that's a little unusual. So they can't keep people. Justices actually don't show up for sessions. Sometimes they have a hard time getting a quorum of justices to actually hear cases and decide them. So the court's really weak as an institution. Those of you who have been to the United States Capitol, you know it doesn't have a building. It meets in the basement of essentially of the Senate, and has to share a room with lots of other people who are doing other things for the legislature. It's a kind of strange situation today to us. If you take your students to D.C., you go to the Supreme Court building, and there's this kind of Greek temple where these gods sit back in there and preside. It wasn't like that at all in 1803. It was just a collection of people living together in a tavern in Washington, D.C., which was itself a backwoods swamp, collected together. Maybe you've got a quorum, maybe you don't. Will this thing even work? The court's really weak. And in fact, one of its decisions, it's so weak in 1803, one of its decisions, Chisholm versus Georgia in 1793, has already been overturned by constitutional amendment. The 11th Amendment was deliberately adopted to overturn a decision of the Supreme Court. So even when it's actually made a constitutional decision, its decision is overturned. So it is a really weak institution. That's the first thing. The second, it's caught between that as an institution and the need, and Marshall's need to preserve whatever strength it has. I think that's really important. In 1803, Marshall sees that the court is weak. He's been on the court for 2 years. But he wants to preserve whatever strength it has. And that's really important because the second conflict that it's caught in is the conflict between the High Federalists and the Republicans after the election of 1800. There's a great battle going on over the Republicans' repeal of the Judiciary Act of 1801. The Republicans come into power. They pass a bill that essentially repeals what the Federalists did in trying to strengthen the federal judiciary, because the Republicans hate the federal judiciary. And they want state courts to have a lot of power, and they don't want the federal judiciary to have power because they think that it's a bastion of Federalists who lost politically and have retreated into the judicial branch. So, and in fact, there's a case winding its way up that we don't hear much about anymore, up through the federal system to the Supreme Court in 1803 called Stewart v. Laird, which was, at the time, most people thought, boy, that's really the politically charged case, because it had to do with whether or not the repeal of the Judiciary Act was itself constitutional. And if the Supreme Court sides against the Republicans in Stewart v. Laird, all hell could break loose for the court. Who knows what could happen? They could completely wipe out all funding. They could kick it out of its building. No one knows what's going to happen. Marshall's caught between the Republicans who want to get at the federal judiciary and the high federalists on the other side who insist that the court defend itself and take the Republicans to task for what it regards as an unconstitutional bill. The high federalists are pushing Marshall to intervene and strike down the bill. The Republicans are saying, just go ahead and try it. If you do, it'll be the end of you and of the federal judiciary. And Marshall is caught in between this, and interestingly enough, so is Thomas Jefferson. Jefferson was no great fan of the federal courts, but in 1803, he was not a bitter rival with John Marshall. That's kind of a historical myth. They were not friendly, but they did not hate each other. Both of them, Jefferson was actually trying to moderate some of the radical Republicans, and Marshall was definitely trying to moderate some of the high Federalists, because they didn't want a decisive clash like this so early on in the Jefferson administration. But Stewart v. Laird is coming up behind Marbury versus Madison. In the meantime, we've got this case, Marbury. It comes up, and as you know, there are kind of three important questions. It comes out, the facts are, as you probably know, William Marbury is given a commission to be Justice of the Peace in Washington, D.C. by the Federalists in the Federal Judiciary Act of 1801. His commission is signed and sealed by President John Adams, but it doesn't get delivered to him. For whatever reason, historically, we're not quite sure why. The acting Secretary of State doesn't give it to him. Now, of course, ironically, the acting Secretary of State who doesn't deliver the commission to Marbury is John Marshall, who, in the haste of the last days of the Adams administration, doesn't get it delivered to him, but in the meantime, he's actually confirmed as Chief Justice of the Supreme Court. So we have a very weird situation here where the Chief Justice who ends up writing the opinion was actually involved in the events that led to the case. Marbury sues James Madison, the new Secretary of State, for his commission. He says, look, Adams signed it, Adams sealed it, it's mine, I deserve it. And he sues Madison under Section 13 of the Judiciary Act of 1789, which basically created the federal court system. And that Judiciary Act gave the power to the Supreme Court to issue what's called a writ of mandamus. It's our first paragraph there. I'll read it. At the last term, on the affidavits then read and filed with the clerk, a rule was granted in this case requiring the Secretary of State to show cause why a mandamus should not issue, directing him to deliver to William Marbury his commission as Justice of the Peace for the County of Washington in the District of Columbia. A writ of mandamus is a judicial order to some official to do something that they're legally required to do. So you go to a court, you say, hey, judge, tell that guy to do what he's supposed to do. In this case, Marbury says, hey, Supreme Court, tell Madison to do what he's supposed to do and give me the commission that was signed and sealed. Madison refuses. In fact, the Jefferson administration completely ignored the case. They didn't even send anybody to defend themselves in front of the Supreme Court. They just said, we don't believe they have any authority in this. We decided we're not going to even defend ourselves. So you have this weird situation where Marbury's side shows up to argue in front of the court. Madison's side does not. Marbury makes the argument. The Supreme Court hears the case. They decide unanimously. It's a really, according to Marshall's biographer, he read the decision, all of it. You have a very edited version. It's a long decision. He read all of the decision, the top floor of a tavern in Washington, D.C., which was packed with people. Because the question was, in their minds, the political gossip of the day was, is Marshall going to force Madison to hand over this commission? And if he does, it's going to be sensational. It's going to be a conflict. There's going to be politics everywhere. Because what if Madison refuses? What's Marshall going to do then? Is Marshall going to call Madison's bluff and force him to issue it? And if he does, will Madison just refuse anyways? That's the political conflict that at the time people are thinking is the most important thing about Marbury versus Madison. Okay, 3 questions. Does someone want to read for us what the three questions are, how Marshall structures the case? Someone would, please. There on the first page of the decision.
Who can I call on to do this? Can I pick on Nancy Lindblom? Oh, we have a hand.
All right.
We have a hand.
Go ahead, please.
Nancy, can I pick on you? How about Laura May? Go ahead, Laura May.
Number one, has the applicant a right to the commission he demands? Number two, can you hear me?
Yeah, go ahead.
Okay, number two, if he has a right and that right has been violated, do the laws of his country afford him a remedy? And then where's three?
There is no three. If
Yeah.
they do afford him.
Well, the third question that Marshall lays out is, maybe you don't have it there. He says is, does that writ, can the court issue that legal remedy to Mr. Marbury? All right, let's take the first one. Does Marbury have a right to the commission he demands? What's Marshall's answer to that?
Yes.
What? Go ahead. Go ahead. Was that Laura May?
No, it wasn't me.
Oh, somebody jumped in and said yes. Whoever said yes, tell us what Marshall says, please. Go ahead. Whoever said that, jump in and tell us what Marshall says here.
No.
Laura May, did you want to go ahead?
Well, it's because he does. Well, I talk to my students about it. He does say yes because the legislation had said this was his job to do it, and he should have done it. Shame on him. But I can't find it. I'm not a quick fast reader. I'm old.
Anne, did you want to go ahead?
Yes, if you look at the top of page 11, number 2, Marshall clearly states that, yes, even though Marbury was a midnight judge, number 2 states that having this legal title to the office, he has a consequent right to the commission, a refusal to deliver, which is a plain violation of that right, for which the laws of his country afford him a remedy. It remains to be inquired whether he is entitled to the remedy for which he applies. So the right of him to collect it is not in dispute here. What seems to be in dispute here is the remedy that can be offered by the Supreme Court.
Here comes Jeff.
Did everybody catch that?
Yes, we heard that. I think Jeff was having a little bit of technical issues on his end, and I think he was moving to a different computer.
All right.
Bear with us for a moment.
Okay. Can you hear me now?
Yes.
Okay. Let me repeat that. Marshall's saying yes. You're absolutely. Whoever responded there was exactly correct. If you have a commission that's been signed and sealed, it is a commission. According to the Old English common law, it's a commission. And that's what Marshall's using here. It says it's a commission, he has the legal right to it. You know, if a courier were bringing a commission to you and dropped it in a mud puddle and it didn't get to you, it doesn't mean you don't have the commission. It just means the courier failed to deliver it. That's the same thing here. He says Madison is just a courier. He's supposed to hand over the commission from the previous administration. So number one, he has a vested legal right to it. As he says here, and has that right been violated? Yes, he says, because they have a legal duty to deliver the right. This is not a matter of executive discretion. This is not a matter of foreign policy where the president has a lot of room to maneuver and is just, you know, has to be allowed a lot of discretion and executive privilege, which Marshall actually discusses here. He says it's not that. This is a legal duty the president has. He has to give over. Now, you can imagine the people in the room listening to this. Immediately, what they're thinking, of course, is he's going to rule in favor of Marbury. He's going to force Madison to give him the commission. It's going to be political mayhem. Then we get to the third point. Does he have a right to get a writ? Does he have a right to mandamus? That's the second point. He says, yes, he does. A court should issue the order to Madison to produce and give him the commission. But then the question becomes, the third one is, but is it the Supreme Court that should issue the writ? And there he says, everyone's holding their breath. He gets to the very last point, and he says, no. It's not within the Supreme Court's power to issue the writ of mandamus. Why not? Well, remember, Marbury sued under Section 13 of the Judiciary Act, which said that the Supreme Court could give him a writ of mandamus. And he was just saying, well, I'm just following the law. The law says I can go to you, and you can tell Madison to give it to me, and he has to give it to me. And this is Marshall's famous discussion of judicial review on point 3. First thing he has to establish is, look, this guy does have a legal case. Because if he doesn't establish, lots of people have said, well, why did Marshall do it in this order? Why didn't he just start out by saying, sorry, Mr. Marbury, we can't help you. We can't issue the writ because the law that gave us that power is unconstitutional. Why didn't he just start there? And the answer is actually, I think, twofold. One is political. Marshall did not want to back down and make the Supreme Court look too weak in front of the Jefferson administration, which was so contemptuous of the court, they didn't even send a lawyer to argue in front of it, right? If he had not done that, and if he had said, refused to address the issue of whether Marbury had a right to that commission, the court would have looked weak. But I think there was also a very important legal reason. The second reason is that in order for Marbury to be standing in front of the Supreme Court, he had to have a legal right to sue. Otherwise, you just have to dismiss the case and not take it. So the fact that Marshall's even writing an opinion about this means that he believes that Marbury does have a legal right to be there to sue in front of the courts. So it's not just to tweak Jefferson's nose. It's partly that, but it's also to show this is how courts work here in America. If you have a vested legal right, you can go into a court and you can ask for help if it's been violated. And he says, yeah, you have a vested legal right, Mr. Marbury. It has been violated. You should get an order from a court to make Madison hand it over, but it can't be us. Why not? Well, as he says here, because the law that you're suing under violates the Constitution. How does it violate it? Well, he says it gives us, it adds to our original jurisdiction. Original jurisdiction means the Supreme Court sits as the very first court to hear the case in the federal system. Most original courts in the United States are district courts, right? If you have a trial, you go into a federal district court, and then if you lose, you appeal to a circuit court. Then if you lose, you appeal to the U.S. Supreme Court. Sometimes, in very rare circumstances, outlined in Article 3, Section 2, the Supreme Court sits as a court of original jurisdiction. It sits as essentially the trial court. Section 13 of the Judiciary Act had said the Supreme Court will be the first court that you can go to get a writ of mandamus to force some executive official to do something that you want done, that you have a legal right to. here Marshall looks at Section 2 of Article 3 and says, yeah, but it's not in Section 2. It tells us what our original jurisdiction is. We're the first court to hear cases involving states against states, California versus Utah over the Colorado River water, New Jersey versus New York over who owns the Statue of Liberty. These are all actual original jurisdiction cases where the Supreme Court was the actual first trial court. But not in this case. A writ of mandamus is not in there. The law cannot add that to it. And if that law does, the law is unconstitutional. And he concludes the decision then by saying, and we cannot follow a law that we regard as unconstitutional. If we interpret the law as unconstitutional, we can't follow it. And as you can see on the screen here, he says, first of all, it would just leave the legislature unchecked. But second of all, he says it would actually go against the conscience of the judge. Why? Because they took an oath to uphold the Constitution and discharge their duties according to the Constitution. And I'll read it here. He says, why does a judge swear to discharge his duties agreeably to the Constitution if that Constitution forms no rule for his government, if it is closed upon him and cannot be inspected by him, interpreted by him? If such be the real state of things, this is worse than solemn mockery. To prescribe or to take this oath becomes equally a crime. What Marshall is saying here is, we take an oath to discharge our duties under the Constitution. That means we have to have the power to interpret the Constitution in the course of carrying out our duties. You come to us asking for a writ of mandamus. You have every right to one, but I'm sorry, we can't give it to you. Because to do that would be to act unconstitutionally. And we've taken an oath to abide by the Constitution. Again, this is a lot like the argument from Federalist number 78. What Marshall is saying is, this law is void in our court. I think it's really important to understand what void means originally. Void means that a law does not operate within a federal court. It does not mean that the other branches have to accept that interpretation. It just means that the Supreme Court doesn't have to accept their interpretation. Again, like I said before, it's a shield to protect the independence of the courts as impartial administrators of the rule of law. It's not a sword to hold over the Congress or the president. Right? All Marshall is saying here is, I'm sorry, we can't do what you're asking us to do. He is not demanding, therefore, that Madison hand over the commission. In fact, he says, we can't tell him that. Even though he does owe it to you, it's not up to us. We can't act unconstitutionally. And he concludes then with a paragraph saying, thus, the particular phraseology of the Constitution of the United States confirms and strengthens the principle supposed to be essential to all written constitutions. And remember, the Constitution is a written law that binds the courts too. That a law repugnant to the Constitution is void, and that the courts, as well as other departments, are bound by that instrument. So, like I said, I think the truth here of Marbury is that it's a very limited decision. It's a decision that says we do not have to, we have the power to interpret the Constitution for the sake of guiding our own legal decisions. It's a very careful decision. It's a very careful approach. And it's actually a brilliant one considering the political context. I mean, if you think about it, Marshall gave the High Federalists what they were looking for. He said, Jefferson, you owe Marbury. The High Federalists were delighted by that. And Jefferson actually never liked that about this decision. On the other hand, he gave the Republicans what they were looking for, which is he said, yeah, but we can't force Madison to give you the commission. And he appeared to limit the power of the court even while he was reaffirming its power of judicial review. So sometimes people say that, I think the myth is that Marbury versus Madison established the practice of judicial review. I think it's exactly the other way around. When you really read the decision and understand the context, I think he used the doctrine of judicial review to decide the case. He didn't use the case to establish judicial review. He used judicial review to decide the case in a way that avoided really great political peril for the court and simultaneously affirmed its independence and its dignity as in the constitutional scheme. I think that's the great importance and kind of the triumph of Marbury versus Madison. and why it was so significant in its day. You know, Marbury was never cited throughout the course of the 19th century until the late 1880s and 1890s. It was never cited as the precedent for the idea that the Supreme Court's interpretation is supreme. And the reason for that is pretty simple, I think. That's not what Marshall says. Marshall simply says, we have the power to interpret the Constitution for ourselves so we don't violate the Constitution and are forced to do something unconstitutional. He does not say that the court's interpretation binds the other branches. Now, the question that was asked was, then how does the court become so powerful? And I think that's a process that occurs over time. You know, there's several reasons for it, and I'll just lay out a couple of them, and these are historical reasons. One is that over the first decades of the 1800s, judicial review, the power of judicial review grows and grows to the point where people start looking to the Supreme Court as an interpreter of the Constitution. And it's a role that the Supreme Court accepts, but not because it took that role, but because it was given that role. And especially by the Federalists and then by the National Republicans, people like Daniel Webster, who very strongly argued the Supreme Court really needs to be thought of as the final interpreter of the Constitution. And as you know from reading Andrew Jackson for today, that was not a widely accepted or universally accepted notion. That was a political position that the people who favored national power adopted. And why would they do that? Well, they wanted to offset Republican control of the state legislatures, for one thing, and of the national legislature, so they looked to the federal judiciary to have some power. I think it's also a second reason is that the Marshall Court made rulings that generally upheld the power of Congress and the president. And so since the court kept making rulings that upheld their power, they kept acquiescing to its power of interpretation. I mean, the Supreme Court declared a law unconstitutional in 1803, right, with Marbury. The next time it does that is 1857 in Dred Scott. For 54 years, it essentially never strikes down any significant piece of federal legislation or any executive action. You can see why even presidents and Congresses would have a kind of vested interest in having the power of the court get bigger and bigger with respect to interpreting the Constitution. And I think it's also looked to, a third reason would be that it's looked to solve political controversies that the other branches can't deal with. The most famous example of that was the National Bank with McCulloch versus Maryland, and also with slavery and the Dred Scott decision. Political parties began to look to the court to say, well, look, we're having gigantic political arguments over the meaning of the Constitution. You settle it for us. Again, it's not because Marshall actively, deliberately tried to appropriate that power for the court. I think he was willing to accept it when people gave it, but people handed it over, usually fairly willingly. You know, again, that wasn't the original meaning of Marbury, but that power grew and grew and grew and grew over the course of the 1800s, so that by the time you get to the late 1800s, you have almost everyone in the United States has come to accept the notion that the Supreme Court is the final authoritative interpreter of the Constitution. Everybody, even from the time of the founding, including Jefferson, accepted that it had the power of judicial review. But would it be supreme? Would it have judicial supremacy? That's an idea, like I said, that takes decades and decades to become established. And as you can see from your reading from Andrew Jackson and from Abraham Lincoln, and I would add Thomas Jefferson and several other presidents, there was a long line of presidents in the 1800s who did not accept the supremacy of the court. They said each branch has the power to interpret the Constitution for themselves. Sure, the Supreme Court can interpret it, but so can the President and so can Congress. And the Supreme Court's interpretation does not bind the other branches, just like the other branches' interpretation does not bind the Supreme Court. That scholars today call that the theory of departmentalism. Each department gets to interpret the Constitution for itself. And that was one form of constitutional resistance to the supremacy of the court. It's what Jackson says in his veto message. He says explicitly, I think someone mentioned it already, but he says, I've got it up here on the screen. He says, I'll pull it up here. He says, oops. Yeah, all right, I'll pull it down. If our power over, it says, one more. It is maintained, this is the second paragraph, I'll read it. By the advocates of the bank that its constitutionality in all features ought to be considered as settled by precedent and by the decision of the Supreme Court. He's talking about McCullough versus Maryland. To this conclusion, I cannot assent. Mere precedent is a dangerous source of authority and should not be regarded as deciding question of constitutional power, except where the acquiescence of the people and the states can be considered as well settled. So Jackson says, yes, sometimes precedent, the Supreme Court decisions and interpretations are binding, but only because people accept them as sound arguments and reasoning, not just because the Supreme Court said it. Look at the next paragraph. He says, if the opinion of the court covered the whole ground of its act, it ought not to control the coordinate branches of government. Each branch gets to decide for himself. He says, I, as president, took an oath to protect and preserve and defend the Constitution of the United States. That means I get to interpret the Constitution. Congress, Jackson argues, interprets the Constitution all the time when it passes laws. So constitutional interpretation is something all the branches engage in, not just the Supreme Court. And Jackson says there's no reason why the Supreme Court's opinion should be the final authoritative opinion. If its argument is really good and persuasive, then we'll adopt it. If it's not, we'll reject it. I know the Supreme Court said the bank was constitutional way back in 1819, but I think in 1832 it's not constitutional, and my interpretation is as good as theirs. Like I said, that's called the theory of departmentalism. That theory over the course of the 1800s declines, and by the early 1900s, most people have come to accept judicial supremacy for the reasons that I argued. But still they resist the supremacy of the court. I mean, think of FDR's court packing scheme in the 1930s, right? That was a political resistance to the notion that the Supreme Court is the final authoritative interpreter of the Constitution. Think of the Reagan administration's attack on the court and the way it interprets the Constitution to increase its own powers. I call that jurisprudential resistance. They had a theory of jurisprudence which said the court should restrain itself. Think of President Obama's attack on the Supreme Court in a State of the Union address for its decision in Citizens United. That's a kind of political, rhetorical resistance to the supremacy of the court. Over time, the constitutional argument that Jackson makes and that Lincoln makes against Dred Scott, that has declined. But it doesn't mean that everyone has therefore just passively accepted that the court is the final interpreter. There's still pushback, there's still resistance, but we see it in different forms now. So I would say, again, it's a myth that the Supreme Court decided and settled forever judicial supremacy in Marbury versus Madison. It took decades and decades and decades, lots of political argument, lots of constitutional conflict before that finally became a settled fact. It's not written in Article 3. It's not said in Federalist 78. It's not said in Marbury versus Madison. It had to develop over time. There's actually a very good book on this by a political scientist at Princeton named Keith Whittington called The Political Foundations of Judicial Supremacy, where he basically makes an argument which I find very persuasive, which is the court didn't even take that. The court was given that power because lots of people had interest in increasing the power of the courts because it was making decisions that they liked. So the question that someone had raised is, so how do we get to the court where we have today? It was a long process that took a lot of time, and it grew in fits and starts. It is not rooted in Marbury versus Madison. That decision simply says the court has the power to interpret the Constitution for itself, so it's not dominated by the other branches. It does not say that the court's interpretation gets to dominate the other branches. Okay, we might have questions.
Jeff, we do have a couple of questions, and I'll ask our questioners. We have 3 on the queue. I'll ask our questioners to be quick, and then we'll move on to Brown as we can. Laura May, did you have a question, or was your hand up still from earlier?
Oh, that's from earlier. Sorry.
Okay, that's okay. Karen, go ahead. Karen Green.
Yes, hi. I was just going to ask what the professor thinks now of the point that was made in Brutus regarding, well, you know, you really do have to fear what could possibly happen. And I realize they probably weren't thinking over the course of 200 years. But when you think of Bush v. Gore, for example, in 2000, Bush v. Gore, for our purposes in 2000, seems reminiscent to me of what happened back with Marbury. It's like, well, what if the court does this? What if the court does this? When in effect they reject Florida's appeal to them, and then they decide, okay, on the second turn they will take it, and they do it. Whereas if they sent that back to Florida, if they did what Marshall did in Marbury, then, you know, I realize that would have been out of character, I guess, but I'm just wondering,
right.
Are we, you know, anyway, sorry.
No, I think that's a good question. I think you're raising a good question, which is, okay, even if what I'm saying is true, what bearing does that have on today? I think it's not just a historical point. I think it can have a lot of application to today. One thing is it can restrain, if the court were to reevaluate itself and rethink the history of where it came from, I think it would be more inclined to issue narrow rulings that restrain itself more than it has, certainly since the middle of the 20th century on, both on left and right issues. They sometimes have been much more expansive than was ever warranted by the case itself. So I think that there have been times where the court really could, if it took to heart the lesson, it could narrow itself and restrain itself. The other thing I think is learning this lesson is really important for, first of all, for citizens, just to remind ourselves, yeah, wait, we may have permitted the Supreme Court to be the final authoritative interpreter, but that's because we and the political branches have permitted it, not because it's anything in the Constitution itself. It means that citizens have to be involved in constitutional interpretation. It means that when lawmakers make laws you think are unconstitutional, you have to politically hold them accountable. And you can't just say, well, I guess the Supreme Court decided that issue, that's done with now constitutionally. That's not true. That's not, I would say that's a bad lesson to be drawn from Marbury, and definitely one Marshall himself would not want us to draw. Citizens should be involved in constitutional interpretation. I would say the same thing is true of Congress and the President and the state legislatures. Don't be afraid to push back against what the court rules. Push back directly, push back indirectly by laws that okay, if you say, well, okay, the Supreme Court says this, but maybe we can make a law that sort of gets around it or narrows or restricts the ruling of that, there's nothing unconstitutional or unjust or outrageous about doing something like that. There's nothing outrageous for the president to say, here's my interpretation of the Constitution, and I'm going to act this way. The president should be doing that. You know, regardless of your political persuasion or your views, there have been presidents that have signed legislation and said while they were signing it, I think this is unconstitutional, but I'll let the federal courts sort it out because that's their job. That is a terrible mistake and a terrible application of Marbury versus Madison. Now, the president also has a duty to interpret the Constitution, and if he thinks the bill is unconstitutional, then he should say, I have a role in interpreting the Constitution too. So like I said, I don't think it's just a historical point. If you understand that supremacy of the court has grown on time, you know that over time it's going to restrict itself and come back to a little bit something that's a little bit more moderate, I think, and a little bit more according to a vision of a constitutional republic that the founders have set up. I think there's no reason why Congress shouldn't pass laws that push back against the court. The president should push back against the court, whether you agree with a particular court or not. I think that's extremely healthy. I'm always glad to see it, and I hope that's one of the lessons learned from really understanding the narrow meaning of Marbury. It doesn't harm the court when you push back. It's good for the court. Makes them rethink, argue again, makes them take other cases and do some reasoning themselves. Somebody else has other questions.
Jeff, we have a couple other hands up, but we do also have the Brown case.
Yeah.
If you'd like to move on to Brown, we can move on to Brown. If you'd like to dwell on Marbury a little bit longer, then we do have a few more questioners.
Okay, let's take a couple of questions on Brown.
Okay. Paula, would you like to go ahead?
Yes, I'm still trying to make the difference between the courts being the instruments of law and not will. Would you say that Marshall believed that the courts protected individuals in rights given ultimately by nature and not by government? And then what do you think he thought the role of his interpretation of natural law in the courts was?
Well, that's a really great question. The way Marshall frames it in Marbury is courts are there to protect the vested legal rights of individuals. So that's his phrase exactly. So courts, you might have natural rights, and Marshall was a very strong believer in natural rights and natural law. He talked about it very often, and in his political capacity when he was a politician, he guided himself by philosophies of natural rights and natural law, no question about it. As a judge, he thought there was a more limited role that natural law could play in a court. First question, for example, Marbury. The case, Marbury does not have a natural right to that commission. He has a vested legal right. The law has given him that right by creating the justice of the peace position. Okay, so I think Marshall would say a lot of cases we don't even have to think about what the natural right is here. We can just talk about what the vested legal right is. And if a person has a natural right but has no vested legal right, then what do you do? Marshall confronted that on the kind of question of slavery. The very famous case called the Antelope case, which you should look up online. Google it, Wikipedia it. Look up John in the biography of John Marshall that I'll show you at the end of some sources to read. The Antelope case is a really interesting case because there the question was, if you're not sure if an African person has been legally enslaved and they come to you in front of a court, do you regard them as a slave or a free person? And there Marshall actually held, if you can prove to me that you have legal documents showing that this person is your slave, then they're your slave legally. But if you can't prove that, then under natural law and natural rights, they're a free person who has the right to go free. So there's a case where he did use natural rights and natural law and came down, for example, on the side of slavery, which is an institution he always abhorred and spoke against. But he thought as a judge, he had to protect the vested legal rights of the owners while doing as much justice as he could to the natural rights of people like the slaves. So that's how he kind of put those two things together. Other questions?
Shelley, do you have a question? Shelley Kaplowitz? Did you have a question, Shelley?
Yeah, Jason, she did. She doesn't have a mic.
Oh, okay.
What she said was that she's a high school American history teacher, and while she was listening, she was skimming her textbooks and noticed that all the textbooks on her shelf, all of them say that Marbury versus Madison established or created judicial review. So how is it that so many academics with this degree of influence over the young people, how can they get it wrong?
Good, very good question. That's why I said at the beginning this was kind of a myth-busting session. That's a big myth. How has it happened? Because a lot of people look at what the Supreme Court does today and think that must be how it was understood at the time. And there have been, frankly, I don't accuse them of bad motives or ill will or sort of ignoring history. It's an accepted doctrine of common faith today about the court that we never even question. But I think, as I'm trying to point out, very questionable. How has it happened? Well, the Supreme Court itself, in the case called Cooper versus Aaron in 1958, said we are the final authoritative interpreter of the Constitution. Sorry. It goes back as far as the 1890s when they started making decisions that were somewhat politically controversial. They started saying, yeah, you might not like them, but we're the final interpreter. And people acquiesced in that idea. They just said, well, I guess that's what it means, right? And they lost some of that tradition, like you see with Abraham Lincoln, of opposing that notion publicly. It took a politician of courage to be able to say, yeah, the Supreme Court's not only wrong, but we don't even think they have the final say. And by the time you get into the mid-20th century, the habit has been ingrained in the American people and in American politicians of accepting judicial supremacy, that pretty soon it went from a habit to being a kind of doctrine of faith and an article of faith. But like I said, if you look in Article 3, it doesn't say the Supreme Court's the final interpreter. If you look at Federal 78, if you look at Marbury, none of them say it. It has accumulated over time because it has served a lot of people's interests, and also because some people thought, well, somebody's got to be the final interpreter. Let's let it be the Supreme Court. But that's an argument. That's not a fact, and certainly not a historical fact. So like I said, I think textbooks get that wrong. not out of malice, because they're just repeating what they heard someone else say, who is repeating what they heard someone else say, who originally adopted this view way back when.
Jeff, do you want to move into the Brown case now?
Let's do that. And if other people, if you have questions, I'm happy to talk afterwards, or we can chat in the chat function. But another big historic decision, obviously, that you deal with in textbooks is Brown versus Board of Education. Let me give you the two. We'll have to move a little more quickly, but let me tell you some of, actually, it's helpful that we took Marbury first because it lays some of the groundwork for the discussion of Brown. There are two big myths about Brown. First is that it settled the problem of race in American law. And the second is that it ended segregation in the United States. Those are both myths. Neither one is really true. The truth is that Brown was really just one part, a very important part, but one part of a long struggle against racial discrimination in law. And the other truth is that it didn't settle the problem of race in American law because it really, I think, did not give a coherent, principled understanding of equal protection of the laws that you can take from Brown and apply to other cases after that. It gave us a decision on a particular issue at a particular time, but the meaning of that decision has had to be worked out over time by citizens, by legislatures, by other courts, and it's taken a long time to say, okay, what does Brown actually mean? So I would say that both of those things are myths, and the truth is much more complex and in some ways more historically interesting. It doesn't say that Brown's not an important decision. It doesn't say that Brown's a wrong decision, but it's to say that, again, we've invested back in Brown what is not necessarily there in Brown itself, which, of course, in Brown, to be understood, you have to start with Plessy versus Ferguson, case that I'm sure many of you know very well, that you've taught your students a lot, saying, of course, that separate but equal is constitutional. Separate but equal does not violate equal protection of the laws. And the argument that the court gives in Plessy is separate is okay because it doesn't violate the 13th Amendment, which says no slavery. If you see the Lincoln movie, you know, right, the whole controversy and the politics behind the 13th Amendment, because the 13th Amendment, the court says, was just designed to abolish legalized slavery. Racial segregation in rail cars is not legalized slavery. So they say it doesn't violate the 13th Amendment. But what about the 14th Amendment? How come it doesn't violate equality? And the court's answer is, well, because it's a reasonable police power regulation. Look, governments all the time treat people differently. 14-year-olds can't vote. Is that unequal? Well, it's different, but does different always mean unequal? Well, no, because sometimes different people, not everybody deserves the exact same treatment because they're actually in different circumstances and situations. So 14-year-olds, for the purposes of the law, are quite different from 18-year-olds, and people think that difference is reasonable. That's not unequal. Or if it's unequal, at least it's not unjust. It doesn't deny equal protection of the laws. And the court here says that's the same thing is true of racial segregation. Well, why? Because they say it's a reasonable regulation to keep the races separate in order to protect public peace and order. They say, look, racial tensions are bad in Louisiana between black and white. The state of Louisiana recognized that fact, and they're just trying to segregate the races in order to prevent racial tension and keep public order. If, and a very famous line, they say, well, if the African race derives from that the idea that it's inferior, they say, that's just a problem, that's their problem, essentially, the court says. It's not what the law is actually saying. And on that ground, it says that it doesn't violate equal protection of the laws because the law, the 14th Amendment, passed after the Civil War, right, in 1868, its purpose, they say, was not to provide social equality. It was to provide equality before the law. And as long as the cars are actually equal, being separate does not violate equal protection. It's giving everybody the same thing, rail cars. It doesn't have to promote social equality. That's the argument the court makes. And in his dissent, which is probably the single most famous individual dissent in Supreme Court history, Justice Harlan lays out the argument against it. And it's very important to know this argument when we go into Brown versus Board. Harlan's argument is, first of all, he thinks this violates the 13th Amendment, because the 13th Amendment should give people freedom. In abolishing slavery, it gives people freedom, and he says a free person can sit where they want on a rail car. That's just part of being a free human being. You can go from one place to another and not have government stop you for no good reason. But he says, secondly, it does violate equality. And he says the law is not a reasonable regulation. We know it's rooted in racist motives. It's not to promote social peace. It's to keep black people away from white people because white people think they're inferior. That's the true situation in Louisiana. And he says, look, the law is just exacerbating that problem. It's just making race hate a part of law. But of course, that itself is laying bare the racist motives of the Louisiana legislature is not enough by itself to decide the case. Because Louisiana can say, no, it's not. We disagree. That's not the reason. So he has to turn to another argument. And that's what the paragraph I have here in front of us is where he talks about that. His very famous discussion of the colorblind law. And he says, the law must treat people the same without regard to race. The law must regard people at the same regard to race. Why? Not because the law is trying to enforce social equality, but because the law has no power to see race whatsoever. The law must be colorblind, as he says. It must regard man as man. What he's saying there is really important. He's saying, look, the law treats you as a human being. What are you as a human being? You're a person with rights. You are not a racial being for the purposes of the law. The law has no power to see your race. It literally is colorblind. It just doesn't have the power to see color. Because it's supposed to protect you as a human being, and who are you as a human being? Our Constitution makes clear you are a person with the rights of life, liberty, and property. And if government has no power to see your race, because why does it need to see your race in order to protect your life, liberty, and property? It doesn't. It literally does not have the power to see your race because that power is not necessary for it to do its job. That's his argument against separate but equal. Not that
Bear with us for a moment.
Yeah, okay, good.
You're back.
And thanks. Now, with that in mind, let's look at Brown versus Board. Did the court adopt that reasoning in Brown versus Board? Because sometimes people have said, well, yeah, it overturned Plessy versus Ferguson, and it established the idea that race will have no part in American law, just like Justice Harlan said in his famous dissent 50 years earlier, 60 years earlier. And the answer is no. That's not the basis of Chief Justice Warren's opinion. As he lays it out here in his opinion in Brown, it's a short opinion. He wrote it on purpose to be short. He actually said, I want to write an opinion that can be published in the newspapers that everybody can read. Warren had been the governor of California, as many of you know. He was a politician, and he had the politician's instinct in writing opinions. He said, this is going to be politically controversial. It's going to be politically cause a firestorm. I want a unanimous court, and I want an opinion that can be read by ordinary people, understood by them, and published in all the newspapers. So that's the kind of opinion he wrote. His argument is that in public education, legally separate cannot be equal. Why is that? He does not say because the law has no power to see the race of individuals. He says because of the particular character of public education today. The first point he makes with respect to that is that education is critical to success as a citizen today. Maybe it wasn't in 1868, and he actually says the original understanding of the 14th Amendment cannot help us because it's unclear if the original Congress that passed it was opposed to racial segregation or not. There have been lots of legal argument and historical research on whether that's true or not, but his argument is the original understanding may have tolerated separate but equal in public education, but today we cannot. Well, how come? First of all, because public education is so much more important today. It's essential to your success in life and as a citizen. And the second point then he makes is racial segregation, legal racial segregation, denies equal educational opportunity. So the first thing is, to be equal before the laws, you have to have equal educational opportunity today in 1954. And secondly, racial discrimination by law violates equal educational opportunity. How does it do that? He says, well, it makes young African Americans, like Linda Brown, feel inferior. And those are the psychological studies, the famous ones with the dolls that he cites from Kenneth Clark and others. He said it makes them feel inferior. If you feel inferior, you don't go to school with the attitude of, I'm going to learn everything I can to make something out of myself. You go to school thinking, I'm not really any good and I must be dumb and I can't learn. He says, so makes them feel, African Americans feel inferior, and as a result, they cannot take advantage of educational opportunity, and that denies them the equal protection of the laws. So the court's understanding of equality is not colorblind here. It's that the law should not make anyone feel like a second-class citizen. And he says that's what legalized racial segregation does in public education. That's the argument that could command a majority on the court for Warren in 1954. In fact, commanded unanimous opinion. But of course, it raises the question: why didn't they just go with Justice Harlan's opinion? Why didn't they just adopt the notion that the Constitution is colorblind? I think the first reason is, again, we've got to remember the historical context. And some of you, I mean, certainly my parents were alive as young people in 1954. They remember telling me about the decision. They were in Michigan, a northern state that didn't really have de jure segregation in schools. My mom, as a school teacher, remembers hearing this decision and being amazed by it. But that it was, you know, I think, had they declared that the Constitution is colorblind, the first thing I think why they didn't is it would have been too radical. This was a big enough decision itself. If you declare that the Constitution is colorblind, that means racial segregation in all facilities is immediately unconstitutional. And the NAACP, as you know, started with a legal strategy of deliberately going after education first, because that was such an all-American thing. Then later, after this decision, they started going after public golf courses, public swimming pools, public fountains, all of these things that were also segregated. They started with education first on purpose. So had the court adopted the colorblind thing, it probably would have been too controversial. And because the context that they were ruling in was public education, which really made the ruling possible in the first place. Yeah, people will get that it's wrong in education because they see how important education is. Even if you don't like the ruling, you can agree with that part of it. So I think for those reasons, they didn't adopt Harlan's view. And also I think because Chief Justice Warren's political philosophy was not necessarily amenable to the Harlan colorblind principle. I think there were times when Chief Justice Warren, for example, he had been a fairly significant supporter of internment of the Japanese in California during World War II, which of course was a racially charged with racial questions and problems. So for him to come along and say race is always everywhere a wrong thing, people would have seen as a pretty obvious contradiction to his past actions. So I think for those reasons they didn't adopt the Harlan argument. Therefore, the effect of Brown, because they didn't adopt that argument, the effect of Brown has actually been kind of, I think, exaggerated a lot. That's one of the myths of Brown, that it ended segregation in the United States. That's not true. You can see in Brown versus Board of Education number 2, 1 year later, the court says, well, we really meant it. You really got to get going. And we're going to use our power of equity, our power to fashion a fair remedy to enforce that. But they leave it up to other authorities to enforce it. And so they themselves recognize that they've run into resistance controversy, the whole idea of massive resistance in the South is taking off by this time. They themselves realize the effect of Brown is limited, and they're going to push it as far as they can, but not much farther than that. And the fact of the matter is, very interesting statistics. I got from a guy I was teaching with, Josh Dunn, at the University of Colorado, who's done extensive research on racial discrimination in law. In 1954, only 0.2% of all schools that had been segregated were desegregated by the end of the year. In 1964, only 2% of schools that had been legally racially segregated in 1954 were desegregated. 10 years later, only 2% had been desegregated. In 1968, 34% were desegregated. In 1971, 90% were desegregated. How come? What was the difference? It wasn't Brown versus Board of Education by itself. It was Congress in 1964, in Title VI of the 1964 Civil Rights Act, said, if you want federal funding for education, you will desegregate your schools. Well, as some of you know, the poorest school systems were largely in the South, who relied a lot on federal funding. So they had a hard choice to make. Do we continue to refuse to implement Brown and forego the money, or do we take the money and desegregate? And most of them, not surprisingly, you know, for working for schools, whoever had the money made the rules. They took the federal money and they desegregated. So it was really Congress saying, no, that really is the correct interpretation of the Constitution. You really have to abide by what the court said. It was Congress passing the law, which essentially put into effect the constitutional ruling made by the court in Brown versus Board of Education. Without that, and also, of course, Eisenhower's famous actions in Central High and Little Rock in 1957-58, without the President and Congress acting, Brown versus Board of Education would not have had the effect that it did. It had a moral effect, but an actual political, legal, educational effect, it took a long time for that to happen because the power of the court was so limited. It didn't have the purse. It didn't have the sword. It had to rely on those things. And it also, I think, part of the reason why it was limited in its effect was that the ruling of the court, the foundation of its reasoning is a little unclear. And a lot of people even people who favored its decision at the time in 54, said, yeah, we like the decision, but the reasoning's not very good. And the problem they had with it was that it rested on this notion of psychological knowledge and psychological inferiority. And that became a very difficult thing to prove. So, for example, if you were going to litigate against racially segregated public swimming pools, you had to prove that that created psychological inferiority in black citizens of your town, just like it did in in educational institutions. You had to litigate all of these cases all the time because the reasoning did not allow you to come into a court and simply say, look, it's racially segregated, therefore it's unconstitutional. You had to prove that it had these psychological effects, or you didn't win your case based on Brown versus Board. So the ruling itself its reasoning was so limited that it had a hard time being applied. And in fact, the weird thing is, I just want to bring up this last document that we have, which is the Austin City school system. I don't know if anyone on here is from Texas or from Austin, Texas, but as late as January of this year, last month, they were disputing a program to create single-sex schools, which also would have been essentially single-race schools as part of their middle school program. The ACLU threatened to sue them, saying, and this, by the way, was also proposed by the Detroit public school system in the early 1990s. The ACLU threatened to sue them, saying, look, that will create racially segregated and gender segregated schools, which violates Brown versus Board of Education. The Austin school system has come back and said, no, that's not true. Brown versus Board of Education says racially segregated schools are unconstitutional because they cause psychological inferiority. What if we show you that kids actually learn better in racially segregated schools or gender segregated schools? Then it doesn't violate the reasoning of Brown. And so, in fact, they're going forward, it looks like, with this plan that you have in front of you to create single-sex schools in the Austin School District that will end up being both single-sex and, by and large, single-race. They know it. They're doing it on purpose on the east side of Austin because they say, look, there are minority communities there whose schools have not been working for them. We want to change the way schooling is done, and we think it will actually be better if young Hispanic men can learn together in a school with essentially only young Hispanic men. That will actually further their education. And under Brown versus Board of Education, the question is that right? Does that comply with Brown, or is Brown's reasoning actually in contradiction to its holding in certain circumstances if the psychological situation changes? And I think the ambiguity of Brown has lent itself to a lot of confusion in public education, and we're starting to see that come out again. Now, whether the Supreme Court will come down with a ruling that clarifies all this, as you know from a lot of its affirmative action cases in education, the court still is split on the legacy of Brown. Some members of the court say affirmative action is the legacy of Brown, and some justices say Brown means that we should get rid of all race in education, including affirmative action. And you have these two contradictory arguments because Brown itself has this tension within itself. So it's a myth, I think, that it ended legal segregation, and it's certainly a myth that it settled the question of race in public education in the United States. It's still an ongoing question and problem. People may have questions about this.
If you have a question, go ahead and click the raise hand icon, and we'll make sure to call on you.
I noticed that I have a private note saying someone teaches in an inner city school, and they think that Warren's psychological premise is correct, that people who feel like they're segregated into a school don't think they're capable of success, and it really does affect their education. But of course, the interesting question would be, what if a school district says, be a proud young, this is what Detroit said in 1992. We have a problem with young African-American men dropping out of school. We want to design a school that's for young African-American men, taught by African-American men, using an African-centric curriculum. Why? To instill racial pride and self-esteem in the students so that they will be better students and citizens. And they were very serious about this. They were going forward with it. But again, as I said, they were threatened with a lawsuit on the grounds that that violated Brown. And they said, no, it doesn't. Now our psychological knowledge has changed, and we know that kids learn better in this way. So we're still living with that controversy. Go ahead, Alexandra.
Is there any legal precedent, besides Brown, that says, the Supreme Court has decided, again, English teacher, sorry, not as much historical knowledge as I should have, that has said, you can't separate the races, or was it all an act of congressional funding? Was it, budgetary/executive discretion that forced the issue?
That's a good question. There were Supreme Court decisions in the early 1970s, for example, Milliken versus Bradley, or Charlotte Swan v. Charlotte Mecklenburg, dealing with busing and integration. So what if you had a legally segregated school system, now it's desegregated, do you have to racially integrate it? Do you have to take positive steps to integrate it, or is it enough just to no longer legally segregate? And for a while, the court said you have to take positive steps to actually integrate previously segregated systems. Busing, for example, and the big controversy over busing. That's what that came out of. Since then, the court has backed away from that. But it pushed it in the early 70s and has backed away. So I think the court has been less instrumental in these situations than Congress has with things like funding.
Any other questions before we call our session to a close? Oh, I hear a question. David, do you want to go ahead?
Yes, this calls for some speculation, but I'm just wondering if, through some miracle, the court should decide to go with a color blindness option, whether or not that would kind of a ruling would preclude either gender separation or racial separation on the basis that, on the kind of sociological basis that you've just been describing. I know there are a lot of schools right now, most of them private, that do a coordinate education model with girls attending classes not without boys, and boys doing the same thing. I'm just wondering if, in fact, the color blindness would then, as I say, preclude that kind of an arrangement?
Very good question. First of all, I don't think it'll be a miracle. If the Supreme Court strikes down race in education, they ruled something like that already in 2007 about Seattle public schools. They didn't say it was automatically always unconstitutional, but Seattle had a system of racial allotment of students based on race for the sake of racial balancing in their schools. The Supreme Court struck that down. And this year, they have decided to take a case about affirmative action and use of race in admissions in the University of Texas. Sorry, I'm back. That they've decided to take a case from the University of Texas, from the University of Texas university system, and one of the justices who was in favor of use of race for affirmative actions 10 years ago, Justice O'Connor, has been replaced by a Justice Alito, who is not probably in favor of that. So I think you could actually this year have a decision that on the university level, race cannot be considered. Now, will that filter down into K through 12? Yes, I think inevitably that it will. Will it transfer over to gender? That's a harder question because the Supreme Court has never been quite as suspicious of gender distinctions as it has of racial distinctions, but probably with some good reason, right? Those of you who teach in coordinate schools where you have all girl classes, it doesn't seem totally unreasonable that the presence of boys in a girls' class might be disruptive. That seems more reasonable to a lot of people than the idea that, well, if you have a black kid with white kids, somehow they're going to have an automatic disruption. So race and sex, gender have never been thought of as exactly the same distinctions according to the court, but I think the tendency will be toward restricting those things and toward making school systems give a really good reason why they have to have race or certainly even gender in these decisions. So it might end up restricting what schools can do some. I wouldn't be surprised by that in the next 3-4 years.
And Alexandra, do you want to have the last question of the day?
It's kind of a big one, so if you can't answer it, that's okay. I kept coming up against the tyranny of the majority, this idea that, like, you know, with Brown versus the Board of Education, you have a majority of people who don't want black kids integrated with their, you know, their white children. And so, you know, do you know if the courts, like, what's the court's response to sort of maybe this idea that it has a responsibility to counteract the tyranny of the majority?
Yeah, the court has, well, again, all the way back from Marbury, the court has always had a strong tradition of saying, look, if the law commands it, then we have to do it, and we have to enforce the law even if the majority doesn't like it. There's been a strong tradition of that from Marbury, Brown being a really controversial case of that, and on and on. There have, however, been other times where the Supreme Court has kind of sidestepped constitutional issues because they knew that a vast majority of the American people would be opposed to what they might rule. So there have been times where they say, damn the torpedoes, full speed ahead. We're going to say this is majority is tyrannizing a minority unconstitutionally, and we're going to step in on behalf of that individual. And there have been other times where they've said, well, the tyranny is not so obvious, so let's let the political process work itself out. The example that I would give on that in public schools is actually Under God and the Pledge of Allegiance. That was ruled unconstitutional, as some of you know, by the Ninth Circuit about 5-10 years ago. The Supreme Court took the case, and they very cleverly decided to avoid deciding the case because they knew that if they decided against Under God and the Pledge, the vast majority of the American people would be totally outraged, and you might have some kind of constitutional amendment that overturned their decision. And there they just said, we'll let the political process work itself out. We don't think this is such a bad thing. So depending on if they see a real tyranny, an unconstitutional tyranny, they'll act. If they're not clear or sure about it, very often they'll restrain themselves.
Doesn't that upset the balance? You know, because again, like if we have you know, and I know this, we live in a republic, right, representative democracy. You know, if the people want a law and then that's the majority rule, and then you have the Supreme Court come in and say, yeah, that law is, we don't care what you want, that, you know, like that interpretation question. It's not what you want that's important. It's, you know, we're following, we think this is unconstitutional. You know, that's what I come, you know, because on one side you have people say, well, this is the tyranny of the majority, and other people say, hey, this is what we want as a country, so I don't care if you don't like it, you know?
Right. Yeah, that's justices call that the counter-majoritarian difficulty. Justice Brennan famously said that. Look, what the Supreme Court, going all the way back again to Federalist number 78, the Supreme Court has always said when Congress passes an unconstitutional law, it's not the people speaking. It's Congress speaking. The people have spoken. Sorry, the last word on that. What they say is the people have spoken in their Constitution. If Congress passes a law that violates the Constitution, Congress is not doing the will of the people. Congress is violating the will of the people.
And so that's where the amendment process would come in.
Exactly. That's what.
Okay.
Well, on that note, I would like to thank Jeff for joining us today. I thought this was an outstanding seminar, and we've had a number of people in the chat window telling me and our host what a great job he's done. So thank you, Jeff.
Thanks for having me. I appreciate it.
And as we leave today, I want to let all of our participants know that the Ashbrook Center in the fall semester of 2012 launched live online graduate courses in American History and Government. We use this WebEx Training Center platform to facilitate online seminars. You'll be in courses that are capped at 16, so this is not like your traditional online learning where it's anonymous or where it's a massive online lecture. This is a real online seminar interaction. If you're interested, please contact us at info@teachingamericanhistory.org or take a look at our website, teachingamericanhistory.org, for more information. As you leave the Training Center room today, you will be asked to complete a survey, and this will give us information from you about your experience today. Also, it will give us an opportunity to get an address from you where we can send a letter documenting your participation today. So thank you very much. Thank you, Jeff, and have a great weekend, everybody.
Thanks very much.
You don't have to sign out, and either just click the click out of the screen, or if you go up to File, at the bottom, the last option is in training or leave training session, and that'll get you out of the session. I've had a couple questions about where to get the survey. When you click out of the session, it'll pop up in a web browser for you. If it doesn't, you can email us at mag@ashbrook.org, and we will send you the link direct. But it should come up as you leave the session.